Good afternoon, everyone. It's about 5:31, and we had a start time at 5:30, so I figure we'll kick off. We've got about 40 minutes of a presentation here with about 20 minutes set aside for questions and answers afterwards. So thank you for joining us this evening on this very rainy day. My name is Adam S. Friedman, and I'm an attorney with my own firm, the Adam S. Friedman Law Firm. I'm also the program administrator for the 2026 GCAC Lawyer Referral Services Program. Today's workshop is a practical guide to the 2026 program. The goal here, I'll just take this off. The goal is to not turn this into a legal lecture or to answer individual legal questions in a public setting. The goal here for today is to explain how the program works, what kinds of legal services it can help with, how artists can use the referral process, and what to expect if they are matched with a participating attorney. I want to emphasize at the beginning that this is an informational overview only. Nothing in this presentation is legal advice for any specific person or situation. If you do have a legal issue that applies to your own contract, business, lease, trademark, or other matter, that question should be discussed directly with an attorney through the proper attorney-client relationship. With that said, this program is designed to make that first step easier. Legal help can certainly feel intimidating, expensive, or hard to navigate. This workshop is meant to make the process clearer and more usable. Here is the roadmap for our discussion today. The presentation follows the general same path an artist will experience when using the program: eligibility, referral, attorney engagement, covered services, payment, completion, and feedback. First, we'll talk about the purpose of the program. That means what the program is designed to do for artists and why the structure matters. Second, we'll walk through how the process works. That includes the grant process, intake with the program coordinator, referral to a participating attorney, completion of the legal service, and the post-service survey. Third, we'll spend some time on the covered legal services. This is the heart of the presentation because artists need to know what kinds of legal issues fit the program and what is outside the program's scope. Finally, we will discuss rights, responsibilities, and safeguards. That includes payment, confidentiality, dispute procedures, complaints, attorney participation requirements, and program evaluation. The main theme here is practical use. By the end of the presentation, you should understand when to reach out, who to contact, what questions to ask, and what to expect from the program. Before getting into the step-by-step process, it's important to understand why the program has rules and guardrails. This is not just an informal list of lawyers. It is structured as a lawyer referral program, and Ohio Supreme Court lawyer referral rules require clear procedures. Those rules address several areas. The program must operate in the public interest, use standards for attorney participation, must have fee rules, measure client satisfaction, have procedures for complaints, and be able to report required information. For artists, the practical takeaway is that these rules are meant to protect the integrity of the program. They help make sure the program is not being used to inflate fees, steer referrals improperly, or blur the line between GCAC, the coordinator, and the attorney. The program's public interest purpose is to support access to legal help for artists in Columbus. The program uses attorney standards so that participation is not random. It uses fee rules so artists have predictable costs. It also uses feedback and complaint procedures so the program can evaluate whether it is working. This slide is not meant to make everyone an expert in lawyer referral rules. It is simply the foundation for why the program is structured carefully. At its most basic level, the GCAC Lawyer Referral Services Program connects eligible artists with participating attorneys for defined, affordable legal services tied to the artist's professional needs. The core idea is that this is a structured
Michelle
referral
and
program.
Molly created those luscious Italian rum cakes. The judges gave their top.
The core idea is that this is a structured referral program. GCAC provides funding support. The program coordinator helps make the connection. The attorney provides the legal service directly to the artist. The practical value is that the program saves artists time and reduces uncertainty. Columbus has many attorneys, and attorneys vary widely in rates, experience, and areas of expertise. It can be difficult to know who to contact, especially if you have never hired an attorney before. This program helps solve that problem by connecting artists with participating attorneys who meet program criteria and who are available to provide defined services under the program. One boundary is very important to note. GCAC is not the artist's lawyer. GCAC does not supervise legal advice, and they are not responsible for the attorney-client relationship. The legal relationship is between the artist and the attorney. That boundary protects confidentiality and keeps the roles clear. The program is designed for artists who are eligible through a GCAC Legal Grant Award and who need assistance with common legal issues connected to their creative work. Eligible participants, there we go. Eligible participants include artists working in disciplines such as dance, fashion, film, literary arts, music, theater, visual arts, and multidisciplinary arts who meet GCAC's definition of a working artist and receive a legal grants fund award. The program is meant to address practical legal needs that frequently come up in artistic work. That includes contract, business organization, lease review, and trademark renewal. It is also important to say what the program is not. It is not a general legal hotline, nor is it unlimited legal representation. It's certainly not a litigation program, and it's not a substitute for full-scope legal counsel in every legal matter an artist might face. The program is intentionally limited. That limitation is not a weakness, it's what makes the program usable. A defined scope allows the program to offer practical services at a predictable flat rate fee. This slide explains why the program matters from the artist's point of view. For many artists, legal help can feel intimidating or open-ended. Artists may assume that calling a lawyer means signing up for an expensive process with no clear endpoint. As a result, they may wait until a contract is signed, after a problem has started, or after a deadline is passed. The practical promise of this program is to turn legal help into a defined, usable step in an artist's professional work. It is accessible because artists do not have to navigate the private legal market entirely on their own. They have a program pathway and a coordinator who can help route the request. It's predictable because the flat fee model gives artists a clear expectation of cost before committing to the service. It is focused because the program concentrates on issues that commonly arise in artists' careers and that can be handled within a limited engagement. The program is at its strongest when artists use it early. Think of it as a checkpoint before signing, filing, forming, renewing, leasing, or committing to obligations. One of the most important slides in the presentation, a successful referral program depends on clear boundaries among GCAC, the program coordinator, the participating attorney, and the artist client. GCAC supports and facilitates the program, but GCAC does not provide legal advice and does not become a party to the attorney-client agreement. The program coordinator conducts intake, explains the program process, answers general questions, and helps artists feel more comfortable before connecting them with an attorney. There are no stupid questions at intake. If an artist has never hired an attorney and feels nervous or intimidated, the coordinator can help explain what the process generally looks like. The coordinator will be able to answer general questions about the program or the process. If the question is legal in nature, the coordinator will direct the artist to the attorney. The attorney provides legal services directly to the artist. The artist is the client and makes decisions about the legal engagement. That separation is intentional. It protects confidentiality, prevents confusion, and makes clear who is responsible for legal advice. This slide here gives the full program flow from beginning to end. The process is meant to be predictable. It begins with the grant application. From there is the grant funding and contract steps. After that, the artist may contact the program coordinator if they want to use the referral program. The coordinator conducts intake, identifies the legal service category, and makes a referral to a participating attorney when appropriate. Once the referral occurs, The attorney evaluates whether the matter can be handled. The attorney checks for conflicts, confirms the scope, and enters into an attorney-client agreement with the artist if both sides decide to move forward. After the legal service is completed, the attorney confirms that completion. The artist will receive a receipt, invoice, or a statement of services. The program then uses a survey to collect feedback about that experience. The artist side is deciding whether legal help is needed and contacts the coordinator. The coordinator side is administrative intake and referral. The attorney side is legal analysis, legal advice, the engagement agreement, and completion of the service. The message is that the process is not mysterious. Each step has a purpose. The legal referral opportunity begins with the artist GCAC funding relationship. The legal service is treated as an optional expenditure connected to the GCAC supported artist. The legal grant application window is open now through September 1st, 2026. Artists should apply early and plan ahead because GCA review and approval may take up to 60 days. That timing matters. If an artist waits until a contract is already due, it may not be realistic to apply, wait for approval, get matched with an attorney, and complete legal review before a response is required. The artist should also understand that the lawyer referral program is an optional pathway. The artist is not required to use the referral program if they do not need it. The grant may be also used with an attorney outside the program. However, outside attorneys do set their own rates, so artists should not assume the grant will cover the full cost of those legal services. Documentation matters because the program uses written agreements and receipts to make the scope, fee, completion, and reporting expectations clear. Step 2, the program coordinator is the artist's first program contact for routing and intake. The coordinator is not there to provide legal advice, but the coordinator does help artists understand the program process and move in the right direction. During intake, the coordinator may ask what type of legal help is needed, what deadlines may exist, what documents are involved, and whether the issue appears to fit one of the covered legal service categories. The coordinator cannot interpret contracts, recommend legal strategy, draft legal language, or tell the artist what legal decision to make. Those are attorney functions. The best preparation for an artist is to be ready to describe the issue clearly, identify urgent dates, and explain what kind of document or legal question is involved. The artist should not send contracts or other legal documents directly to the coordinator for review. Those documents should go to the attorney once a proper attorney-client relationship exists. The coordinator's role is to make the process less confusing and help route the request. Legal judgment belongs with the attorney. Step 3. After intake, the artist may be referred to a participating attorney whose experience aligns with the requested legal service. The purpose of the referral is to connect the artist with an attorney who can provide the defined legal service under the program structure. The referral is a connection. It is not a forced attorney-client relationship. A referral does not require the artist to hire that attorney. The attorney should still ask questions and to decide whether the artist is the right fit and vice versa. If either the artist or the attorney determines that it is not a good match, the artist may contact the program coordinator for another referral. The attorney also has responsibilities at this stage. The attorney must evaluate conflicts, confirm the scope, and determine whether the service can be handled within the program engagement. Sometimes an attorney may need to decline, narrow the scope, or explain that the issue requires a different kind of representation. The artist, however, remains the decision maker. The attorney remains responsible for the professional judgment, and the coordinator facilitates that connection. Step 4. This is the point where a referral becomes an actual legal engagement. The attorney-client relationship begins through a written engagement agreement. The agreement identifies eligibility, the specific legal service, the $300 flat rate fee, payment terms, confidentiality, and dispute procedures. This agreement matters because it creates the attorney-client relationship, confirms that the artist is the client, and limits the work to the legal service described in writing. Most attorneys use some form of engagement agreement. Program attorneys use a standard version designed for clarity and consistency. The agreement will identify the client, the attorney, the covered service, the fee, payment expectations, and any anticipated costs, such as filing fees. The no-scope creep concept is important. If additional work is needed, That additional work should be handled through a separate attorney-client agreement before extra legal work begins. The artist should not be surprised by work or fees outside of the defined program service. In plain terms, the engagement agreement is not just paperwork. It is the document that defines the relationships and the limits of the work. GCAC is a facilitator, not the lawyer. This is important as it explains the ethical structure of the program in plain English. The program is structured so that GCAC can support access to legal help without controlling the attorney's advice, reviewing privileged communications, or supervising the representation. GCAC will operate the referral structure, maintain program procedures, collect limited completion information, and use anonymous feedback to improve the program. This boundary matters because it protects the attorney-client relationship. It also avoids confusion about privilege, confidentiality, and responsibility for advice. Once an artist signs an engagement agreement with a participating attorney, the legal relationship is between the artist and that attorney. Questions about legal advice, legal strategy, or the content of a legal document should be directed to the attorney, not to GCAC. Now we're moving on to the covered services. The program is built around legal services that are common for artists and that can usually be addressed through a limited scope, flat fee agreement. The covered categories are business organization, contract review, residential and commercial lease review, and trademark renewal assistance with general intellectual property guidance. The limited scope approach means the attorney provides consultation, review, research, advice, guidance, or professional judgment tied to the specific legal service. For artists, the key takeaway is to think about which category your issue fits into before contacting the coordinator. Are you forming a business, reviewing a contract? Are you having to look at a lease, or are you dealing with the trademark renewal? Also, think about what outcome you would want from the attorney. Do you need to understand the risks? Do you need help filing something? Do you need to know whether to sign or ask for changes? The scope is intentionally defined because it is that which makes the flat fee and referral structure manageable. Under the business organization model, the first covered service here helps artists evaluate, select, and form an appropriate business entity for liability protection, tax considerations, and operational efficiency. An attorney may help by explaining Ohio entity options, evaluating the artist's needs, selecting an entity type, checking for name availability, and filing formation documents with the Secretary of State. Common deliverables may include registering that business name, filing those articles, appointing a statutory agent, attaining an employee identification number, and preparing a checklist of items needed to open a business bank account. For example, an artist may be selling work more regularly, collaborating with others, teaching, performing, licensing creative work, or receiving payments under a business name. At that point, the artist may want to understand whether a formal business entity makes sense. The artist should come prepared with business goals, ownership structure, planned revenue streams, if known, collaborators, preferred names, and questions about liability or operations. The attorney's role is to help the artist understand options and complete defined formation steps when appropriate. The next covered category is contract review. This is likely one of the most practical and commonly used areas of the program. Contract review services help artists understand legal documents before they commit to obligations involving artwork, services, performance, funding, collaboration, or creative rights. Review means that the attorney reviews the document, identifies concerns, explains key terms, and advises the artist on legal risk and practical next steps. The attorney can help the artist understand what the contract says, what obligations it creates, what rights may be affected, and what issues the artist may want to consider before signing. Review does not automatically mean unlimited drafting, redrafting, negotiation, dispute resolution, or litigation. If those additional services are needed, they must be separately agreed to in writing. Timing is critical. Contract review is most valuable before signing, before work begins, and before deadlines make negotiation or revision difficult to accomplish. Once a contract is signed, the issue often shifts from prevention to damage control. The program is best used proactively. This slide here makes the contract category more concrete. Contract review can apply to agreements proposed by someone else or agreements an artist wants someone else to sign. Sales, exhibition, and consignment agreements may involve payment terms, commissions, insurance, installation, ownership transfer, and return of unsold work. For a visual artist, this might mean a gallery agreement, a commission arrangement, or an agreement about how work will be displayed, sold, insured, or returned. Work for hire and independent contract agreements can affect ownership, performance rights, recordings, licensing, creative control, payment timing, and whether the artist keeps rights in the work. For musicians, performers, writers, designers, and filmmakers, those ownership and usage terms can be very important. Grant funding and joint project agreements can involve deliverables, reporting, revenue sharing, intellectual property, scope of work, and project responsibilities. The time-sensitive planning point is important. If a contract deadline is approaching, it may not be realistic to apply for the grant, wait for approval, get matched with an attorney, and complete legal review before a response is due. Artists anticipating a significant contract should apply early and plan ahead. The next category is lease review. Lease review services help artists understand residential or commercial lease obligations that may affect living space, studio space, rehearsal space, gallery space, or another professional use. The program covers review and advice on personal residential leases and professional or commercial leases. The purpose is to identify risks, obligations, and landlord-tenant issues before the artist commits. The program covers review and advice on a lease can affect more than rent. It can determine whether the artist may use the space for a particular purpose, bring in visitors, make noise, store materials, display signage, sublet, renew, terminate, or make alterations. Commercial and studio leases can raise issues that do not appear in a standard residential lease. The program limits matter here. The covered service is review and advice. The program scope excludes drafting, editing, negotiating documents, dispute resolution, and litigation unless separate representation is arranged. Artists should ask practical questions. Does the lease allow the intended use? Are there restrictions on noise, visitors, signage, storage, insurance, subletting, repairs, termination, or renewal? Moving forward on trademark renewal, this is a very narrow service. It is not a full trademark representation. It does not include new trademark applications, comprehensive clearance searches, complex prosecution, opposition proceedings, infringement disputes, or IP litigation. What is included is assistance with filing a trademark renewal when an artist already has a trademark registration that needs maintenance. This limit exists because comprehensive intellectual property work can be time-consuming and very costly. A full trademark search, new application, office action response, enforcement matter, or infringement dispute may require more time and more cost than the program's flat fee structure can support. At the same time, intellectual property is very important for artists. Names, brands, logos, recordings, performances, visual work, written work, and creative assets all have value. The program acknowledges that importance while keeping this particular service focused enough to fit the program. Artists with broader IP questions may still use the consultation to understand the issue and whether additional representation would be needed. Okay, what is outside the program scope? Well, a defined scope at least protects artists, attorneys, and GCAC by making clear what the program can provide and when a separate legal engagement would be required. Outside the covered services are matters such as litigation, dispute resolution, negotiations, extensive drafting, new trademark applications, complex IP work, and open-ended general counsel services. That does not mean that these services are unimportant. It means they are now automatically covered by the program's $300 flat rate fee. Some of these matters require more time, a different fee arrangement, court appearances, extended negotiations, or a full scope representation. If the artist needs additional legal work, the attorney must address that through a separate attorney-client agreement before performing the extra work. The artist should not be surprised by that expansion of work. The attorney should notify the artist in writing if the total legal service is expected to exceed the grant expenditure or program limit. The practical rule is simple. The program covers defined services. Anything beyond that needs a separate agreement and a clear understanding. The fee structure is one of the most important features of this program. Participating attorneys providing covered services must follow the $300 flat rate fee structure for each legal service and may not charge more because the referral service was involved. The artist will pay a flat rate of $300 per legal service for the engagement described in the attorney-client agreement. The program cannot be used to increase the legal fees. If an attorney would normally charge less for the same service, they cannot charge more through the program. In most cases, however, the $300 flat fee is a discount because many program attorneys charge $300 or more per hour outside the program and may spend multiple hours on one of these services. Permitted costs are separate. Direct costs may be separate from the $300 legal fee if they are disclosed and handled under the agreement. For example, the Ohio Secretary of State charges $99 to file for an LLC. Artists should discuss with the attorney whether that filing fee is paid directly by the artist or advanced by the attorney and reimbursed. The keywords are predictability, disclosure, and no surprise fees. This slide will explain how billing works. The attorney will bill the artist directly. GCAC is not the client, not the payer under the attorney-client agreement, and not responsible for attorney invoices. Invoices or payment requests are sent to the artist, not to GCAC. The artist is responsible for paying the attorney under the agreement. The invoice should identify the work performed, the hours or service description, and the fixed rate for the legal service. The invoice does not need to disclose every confidential detail, but it should be sufficient to document the service and the fee. After the legal service is completed, the artist will need a receipt, invoice, or statement of services for GCAC documentation. Artists may redact confidential details before submitting it to GCAC, such as the other party's name or the specific subject matter of a contract, though most invoices already contain limited confidential information. The practical advice is to keep the paper trail, the engagement agreement, invoice, receipt, any statement of services, and final advice or documents received from the attorney. Artists get the most value from the program when they are prepared, responsive, and clear about the legal issue they want the attorney to address. Before intake, identifying the legal question, gathering the contract or document, noting deadlines, and explaining what decision or result might be needed. If the issue involves a contract, an artist might want to know when a response is proper. If the issue involves a business formation, think through who will own the business and what the business will do. If the issue involves a lease, understand the intended scope and use of the space. During representation, respond promptly, provide documents, ask questions, and make sure the scope in the engagement agreement matches the service requested. If the attorney asks for information, documents, or clarification, timely responses help the attorney complete the work efficiently. After completion, pay invoices, keep receipts, preserve the final advice or documents, and complete the anonymous program survey when requested. The artist does not need to know the law before contacting the program, but the artist does need to be organized and responsive so the legal help can be effective. This slide is about program safeguards and attorney participation. Artists don't need to know every technical detail, but they should know the program has a structured process for attorney participation. The program uses objective attorney participation criteria to support quality, professionalism, and compliance with lawyer referral requirements. Attorneys are reviewed for good standing with the Ohio Bar Association with no disciplinary history, who carry professional liability insurance, agree to the fixed fee, and have at least 5 years of relevant legal experience and expertise. Approved attorneys must sign program participation documents confirming their obligations and understanding of program rules. There is also continuing compliance. Attorneys can be suspended or removed from the program for issues such as loss of good standing with the bar, insurance problems, grievance determination, or serious program violations. The main point is that this is not simply an informal list of names. The program has criteria, participation documents, and procedures for addressing problems. Those safeguards support artists' trust while still preserving the attorney's independence in providing legal advice. This slide's content is sensitive, but it's important. The program has a structured complaint process for administrative, communicative, or procedural concerns, while legal advice and representation issues remain governed by attorney-client privilege and ethics rules. A client may submit a written complaint to the program coordinator describing the issue, relevant dates, interactions, and supporting documentation. The coordinator acknowledges the complaint within 5 business days. For appropriate program-related issue, the coordinator may request an attorney respond within 10 business days. The limits are important. The coordinator does not decide legal merits. The coordinator is not a judge, mediator, or replacement lawyer. The coordinator cannot decide whether legal advice was correct or whether a legal strategy should have been different. Unresolved disputes may proceed through informal negotiation and binding arbitration. Ethical concerns may be directed to the appropriate disciplinary authority. The program can address process concerns, communication issues, and program-related matters. Legal malpractice, legal advice disputes, and ethics issues are handled through the appropriate legal or disciplinary channels. After legal services have been completed, the program uses an anonymous and confidential survey to evaluate the artist's experience. The survey looks at attorney communication, timeliness, service quality, dispute resolution if applicable, and overall program experience. The timing is that the survey is sent within 7 days after the attorney notifies the program coordinator that the legal service is complete. Artists are then asked to return that survey within 14 days. The survey measures whether the attorney understood the artist's legal needs, how effectively the attorney communicated, whether the service was timely, how confident the artist felt in the result, how any dispute was resolved if one occurred, and the artist's overall experience with the program. The feedback is used internally. The coordinator aggregates the information and shares summaries with GCAC for internal evaluation and program improvement. Individual surveys are not reviewed by GCAC staff. The survey is not busy work. It is part of how the program evaluates whether the referral structure is working and whether improvements are needed. Artists should think of the program as a practical checkpoint before signing, filing, forming, leasing, or committing to project obligations. Before signing a document, an artist might say, well, I have an exhibition, consignment, performance, an independent contractor, funding, or collaboration agreement, and I need to understand what I'm agreeing to. Before forming a business, an artist might say, I'm starting to sell, teach, perform, publish, license, or collaborate more formally, and I want to know whether I should create a business entity. Before committing to a space, an artist might say, I'm considering a studio, commercial, residential, or mixed-use lease, and I need to understand restrictions, obligations, and risks. These are the moments when the program can be most helpful. The key is to not wait until after signing or after the problem escalates. The earlier the artist identifies the issue, the more useful the legal service can be. As we close, there are a few key points artists should remember. First, use the program early. Contact the coordinator before signing, filing, committing to space, or waiting until a deadline is too close for meaningful advice. Legal review is usually more valuable before the artist is locked into an obligation. Second, know the structure. GCAC facilitates, the coordinator routes, the attorney advises, and the artist is the client and decision maker. Third, keep a paper trail. Retain the engagement agreement, invoices, receipts, statements of service, final advice, and any program survey materials. The broader takeaway is that the program is designed to create access, clarity, and predictability. It helps artists connect with legal support, and it does so within a defined scope and clear boundaries. If you remember nothing else, remember this: use the program proactively. Be clear about what you need, understand who plays which role, and ask the attorney your legal questions once the attorney-client relationship is formed. At this point, I'd love to click this link and show you on GCAC's website the referral program. On this page, you will find it under the 4 artists. funding for artists, and the second one listed below, the grant and lawyer referral program. All the information we just discussed on this presentation is included under full details, under description, eligibility, eligible expenses, a timeline, frequently asked questions, how it's scored, how it's reviewed, and then the area for contracts, payments, and reporting. That brings us to questions. Thank you all for your time. I'm happy to answer questions about the program mechanics, covered services, scope, process, or anything else you'd like to discuss. Everyone has their microphone muted, but if there's a question out there, please feel free to ask or type it into the chat. Thank you for the question, Mark. Mark asked, with trademarks, can you use the program for original filing? Unfortunately, the program does not support an initial application for trademarks. The reason being is that it is a very time-consuming and expensive process that would probably not cover the $300 flat rate fee under the program. Now, attorneys participating in this program can offer general intellectual property advice and assist in the filing of a trademark renewal, but not for an initial trademark filing. Good question. You're quite welcome. Any additional questions? If you do have any additional questions, you can contact Miranda, who is our program coordinator, and you can contact her at I believe it is GCAC coordinator at gmail.com. And my program coordinator or program email is GCAC attorney at gmail.com. And this presentation will have my professional law firm email on it, which is Adam at adamfriedmanlegal.com. And I believe Miranda, our program coordinator, will be providing another presentation in a week or so on all these topics as well. But if there are no more questions, I do appreciate your time tonight and your participation and interest in this program. It's very, very important to make sure artists in our community are protected, and their risk for liability is minimized, and they are successful in their professional endeavors, and that is the goal here. So thank you, everyone, for your time, and appreciate. Have a great one.
Thank you.